Yeah, it's not as easy as saying, too bad there's no protection for fear. Because mental disabilities are always the hardest ones that I see employers struggling with, because there isn't any like overt proof, right? Someone who is a quadriplegic, you can see that. Someone who suffers from panic attacks or generalized anxiety disorder, which is something I've been hearing about a lot, people with generalized anxiety disorder, you don't see it. You don't see their anxiety attack.
You're listening to Legal Skinny Podcast with Trisha Barita. I'm a 15-year licensed practicing attorney in the state of Texas. I created Legal Skinny because when I've been invited to do educational seminars on different subjects in employment law, employers and HR professionals would often ask me, where can they find out a little more information on this or a little more information on that? Look, I get it. There's a lot of resources out there, but sometimes it's confusing and people are so busy. Sometimes people have only 30 or 15 or maybe even 5 minutes in their day to devote to learning something new. On this podcast, you'll hear me have discussions and interviews on topics relevant to employers. Disclaimer though, Legal Skinny is for entertainment and informational purposes only, not meant to provide legal advice and doesn't create an attorney-client relationship. Also remember, laws change or they differ by jurisdiction. So this is not a substitute for seeking legal counsel in your jurisdiction on the current law applicable to you. Employers have always had to deal with concerns and dislikes that an employee has regarding the workplace, some reasonable and some less than so. But in the recent months of the COVID-19 pandemic, there has been a new concern that most employers had not dealt with or heard before: fear. The employee fear to return to work after shutdown orders. The employee fear to stay at work after a positive COVID-19 case has occurred in the workplace. Employee fear they will get sick. Employee fear they will get family members sick. Working through this issue can be more complicated than you might initially think. Today, my guest is both a good friend and fellow colleague and fellow podcaster, Susan Dawson. Susan is a business owner of her own law firm and has been a practicing attorney for 20 years, representing local, national, and international businesses in employment and business law matters. She's located in the Midwest, specifically licensed in both Illinois and Wisconsin. Along with her experience, she has some fancy recognitions, including one of Chicago's notable women lawyers in 2018 by Crane's Custom Media, one of the top 10 best attorneys for exceptional and outstanding client service by American Institute of Legal Counsel since 2016. And she was also awarded the 2018 Top 10 Employment and Labor Law Attorneys for Client Satisfaction by the American Jurist Institute, just to name a few. Since my topic is employee fear and loathing in COVID-19, I knew Susan, being the creative, out-of-the-box thinker that she is, could discuss with me the recent fears that employees have been bringing to light and how employers could consider working through these issues. I enjoyed our lively conversation on a tricky subject, so I hope you enjoy this Legal Skinny episode of Employee Fear and Loathing in COVID-19. Hi, Susan. Thanks for coming on my podcast.
Hi, Trisha. I'm so excited to be here. This is great.
I'm really excited to have you today. You don't even know. So can you give my listeners a little bit about your background and your work?
Sure. I am an attorney in the Chicagoland area. I focus on business law, employment law, commercial real estate. I have a department that I run with various attorneys that work in all of those areas. We generally say that anything a business owner or executive needs is what our firm covers. So that's me. I'm in my 20th year of practicing, if you can believe that. Wow.
Yeah. Congratulations. That's exciting.
Thanks. Who knows? Who knew? I remember the days when I was like a few years out and thinking, wow, one day One day I'll be doing this for 20 years, and here it is.
Here it is. There it is. Yeah. I'm at 15, and that seems like quite a long time, but yeah, right behind you about half a decade. I'll catch up. No, I'll never catch up. I'll always be behind. But Susan, obviously we've been friends for a long time. I'm so excited to have you on this podcast. You know, Legal Skinny was just kind of like a little project that I put together. But I'm so excited that you that I got invited to collaborate with you on one of your brainchilds and my other podcast that I've been working on. So I do kind of want to let everybody know about this other podcast. Can you kind of tell us all about it?
Yeah. So, well, you and I, it did kind of come out of a lot of our conversations and just talking and helping each other and supporting each other through this, especially the COVID time, but even before that. So it's called 3 Bs on the Law. And that stands for 3 bosses.
That's right. Explain that. Make sure explain that.
3 bosses on the law. There's a little wink to other interpretations, but it stands for 3 Bs on the law. And we have a third member with us, Kamel, who is our California B. And we have a great time just talking about all the different ways to look at issues from different state perspectives. Because as we've talked about, the businesses today aren't the way they used to be. They're not just in one state. They're crossing borders all the time, whether it's an employee who's working remote from another border, or they've got a customer in another state, or just anything that happens. So you really need to have that those relationships and that understanding of what the different states are like. And that's what we talk about. We talk about approaching issues that are challenging business owners today from an employment law perspective or business perspective, from all these different state thoughts.
Yeah, I'm just, and it's so fun to collaborate with you, and I'm lucky that you chose me. I got to be the Texas bee, so I've had so much fun. Although there's way too many jokes, and my Texans won't relate to it about Texas related things that the Midwest and California bee make fun of me for. But
yeah. And if you're from Texas and you're listening to this, that doesn't, those jokes won't land. But with people who are doing business and they're in Illinois and they've got an employee in Texas or an employee in California, we've got some jokes about what it's like to do business in these other states. So yeah, it's fun.
I throw my fair share of jokes back at you guys too. So
yeah, we deserve it.
So I always kind of reference it as like being a fly on the wall, listening to 3 lawyers kind of like joke through, discuss through, debate through. We don't always agree on that. So they should check it out if they're interested in kind of hearing the different collaboration, especially, if they work across the US and they do have different laws. I think we kind of get into a bunch of interesting stuff. So so they can check us out, 3 Bs on the Law. It's 3 THREE Bs on the law.com. Yep. And the podcast is great. And it's been so much fun to collaborate with you. But today I have drug you here to talk to me about the ongoing fear of COVID-19 for the employees, like this sort of thing that employers are dealing with when an employee is not wanting to return to work or is in the work situation and there is a COVID-19 positive case, and the fear that goes along with that, and the employer trying to work through that, because it's not an easy thing on what to do in that situation, is it, Susan?
No, I mean, there's very little about what's going on right now that's an easy thing for employers to deal with, right? All things related to COVID and Family First Coronavirus Act are they're challenging for all employers. But that fear concept that's not tied into a specific illness, just, I don't want to go to work because I'm afraid. That's an interesting one that employers are dealing with and struggling with. Yeah.
So that's great. Like the FFCRA, here we are. We have these 6 reasons for paid sick leave. None of them include technically fear of COVID-19.
Right.
Right?
Just fear. I just don't want to catch it. No, none of them include. There's no protection under the Family First Coronavirus Act for that. Yeah.
And that would probably be because maybe the entire workforce of America would go ahead and elect and stay that, and it would stay home.
Right. Right. Who wouldn't be? I mean, no one wants to get it, right? I mean, or, if you're going to get sick, nobody wants that. So Yeah, I understand the fear. The fear makes sense. It's a rational fear. It is. It's out there, especially since so many states, like your state, Texas, that it's booming again. The cases. I haven't checked lately. I don't know where you guys are at, but I know a month ago or so, you guys were booming again. So it can be scary for employees, but there's no protection. There isn't an ability to stay home just out of a fear, as long as you can't tie it to something else, like a anxiety disorder or some sort of disability.
Yeah. So, I mean, there's the hypochondriac, which is a real, legitimate, actual medical condition. If
Mm-hmm.
diagnosed with something like that or some other type of, like you said, anxiety disorder, that would maybe be protected, right? That would be
Yeah.
something. But how does the employer figure that out? Whether it is actual some sort of real medical condition, or if it's just I'm scared to come back to work.
Yeah, it's a challenge, right? Well, when I'm talking to businesses about it, if an employee is saying I'm afraid, then you need to dig into it a little bit and find out, is there a medical condition? What are you afraid of? What is it? Is there something in the office workplace that we can fix? Is it not that you just don't want to go anywhere? You don't want to leave your house? Okay. What's going on? So we've dealt with that quite a bit. A lot of times employees will mention things like my therapist said, and then I'm like, oh, red flag, therapy, you're in therapy, possible mental illness, disability. We got to dig into that one. We can't just ignore the word therapist. So, but yeah, you can't just say no. You have to talk to the employee and find out a little bit more about it.
Yeah, because I think when they're afraid maybe to come back into work, there is an initial thought possibly that, from an employer standpoint, well, okay, you're scared to come back to work. There's a lot of people scared, but, you know, just digging into seeing, is there a medical condition is one option, right? They maybe should dig in. Is there something that they could do? Is there something the employer could do, like to make the workplace safer
Right.
so that they feel better about coming back in? Like, what exactly is the fear about? Because if the fear is about, I work in a room that, I'm sitting, in cubicles next to all these individuals. Well, is there, different options that you could kind of explore to sort of make the workforce feel safer? I mean, don't you think that might be an option?
Yeah. Yeah. I mean, make sure you look through the CDC guidelines and you're following them, right? And the current ones, because they get updated from time to time. Make sure that you're doing, what you can to follow those guidelines. In some states, I don't know where Texas is at, but here in Illinois, we have some guidelines. They're not set in stone, but there's guidelines for, what you should be doing on top of the CDC guidelines and your OSHA guidelines. Making sure that you're following that, but then find out, are employees actually following it, right? Or are employees not, are they not wearing their masks properly? Are they doing other things? Are they leaning over someone's desk without a mask on? Sometimes when we're the boss and we're in our office and we're busy all day long with the door shut, we don't know what's going on out there on the floor, just amongst staff. So making sure maybe there's something there. Maybe they don't want to tell on their coworkers, but maybe there's a concern there that can be corrected.
Yeah, that's a good point. So in scenario, employee complains about how, they feel that the workplace is unsafe. An initial thought of how to address that would be, what do you think, Susan?
If the workplace, if they say it's unsafe, well, I would ask for more information about what is it that they feel is unsafe, right? Is there something specific that they have concerns about? If their answer is, well, COVID could be anywhere and I just don't want to be in a room. Okay, then maybe you need to go down a path and find out if there's some sort of background medical condition that we need to be concerned about. But if they mention things like masks and we were out of hand sanitizer yesterday and people weren't cleaning their hands or something like that, well, that's correctable and we can put that in place. But that doesn't mean the employee doesn't have to come to work, right? If it's employees aren't wearing their masks, okay, we'll make sure we put on a notice. We'll make sure that we enforce that, but you still need to come to work.
Yeah. What do you think about training too? Like exploring that as potential solving, people not following. I mean, you might have a million signs over it. Let's face it, there's like 40 million signs out there now. We go OSHA, CDC, for us, the Texas Department of Health and Human Services. Like, it's just like the signs and the videos. It is overwhelming, to
It is,
say the
yeah.
least, of I don't know how many more signs there could be about how you wash your hands. But yeah, so you got all the signs up, but like people start following. What do you think about training? Is it, you think it's effective in the workforce? Is it something they should explore?
Definitely, definitely, especially management staff, shift supervisors, those types, they should be very well trained on safety protocols and what your protocols are. Whenever I'm doing a presentation to, sometimes I'll do like a discrimination or harassment or whatever presentation to managerial staff, I remind them that they are our boots on the ground. They're the ones who are there. They're the ones who see it. They're the ones who are out there. The executive staff, if you have a C-suite level, or just if it's just you running your office, and like I said, you're always in your office busy, because Trisha and I know, as business owners, we're busy with so many different things that we can't always get out there. So it's those managers that you rely on to make sure that rules are being followed. So training is very important, making sure everyone understands that. Whenever there is an incident, maybe call back in for another training session, run them back through the protocols. This is what we're seeing. Send out notices to all the employees, reminding them, you must wash your hands. You must use the hand sanitizer. You must, here's proper mask wearing rules, right? So yeah, I would stay on top of it, because the slightest slip, and it's a scary slope that people will just suddenly become culturally okay in your office to not wear masks appropriately. And now you've got a potential OSHA violation. Someone gets sick. You've got plaintiffs' attorneys out there that are waiting in the wings to jump on businesses and create lawsuits. So
Yeah, I like that. That, especially the sort of the combination of the mask wearing and the social distancing, which sometimes gets missed. They think, oh, we're doing the social distancing, so, we don't need the mask. Well, that may come down to what particular orders you're under related to it, But
Right.
certainly if you're wearing a mask, CDC and OSHA and them are saying you still are supposed to be social distancing if it's not like these high level masks, right? So that's confusing if management's calling meetings where you're in a room and it's impossible to social distance.
Right. Yeah, that is a challenge. I know. Where do you have these meetings, and how do you talk to everyone so that they can all still be socially distanced? But yeah, that's something people aren't realizing. Just because you have a mask on doesn't mean that you should be right up next to somebody. If it's a short, we're passing each other in the hall, okay, what can you do? But if you're working in close contact with others, or not close contact, but if you could be, you need a mask and socially distance. So unless you can, at least in Illinois, unless you can go into an office and shut the door, you're supposed to be wearing a mask.
And then on top of that, so we've got this COVID-19 potentially fearful employee who may have a medical condition they might want to explore. They may be complaining just about safe work practices, and either, which you may be total valid concerns, maybe totally unreasonable concerns, but just being careful that those individuals have protections around them, like the National Labor Relations Act allows you to complain about your working conditions. Right. And then OSHA is, of course, looking at those whistleblower claims, right?
Right.
So,
and then retaliation is right.
I feel like the retaliation is like not ringing as much into the scenarios when you hear all these issues. I think, there's a natural try to like fix it kind of thing where, yeah, you need to fix it, but also remember we're now talking about 3 different scenarios we've just brought up in our conversation of potential protections that this person has.
Yeah, to me, when I'm talking to businesses about this, the number one thing I'm concerned about is retaliation, because when it comes to retaliation, the underlying claim that was made can be untrue. So the employee can make a claim that people aren't wearing their masks, and it can be completely unfounded. But if you take an action against them, like, you know what, I'm sick of your complaints, you're fired, right? That's retaliation. And even if it turns out that people were wearing their masks appropriately. So retaliation is always concerning, whether we're in COVID land or not. Retaliation is always a big concern. But right now, it's a really big concern. It doesn't mean that if an employee says that I'm afraid and then they refuse to come work, that you can't eventually say, you have to come to work or you're out of a job. I'm not saying that, but you have to make sure that you've followed through, you've talked to them. The word fear or afraid, that should trigger in your head, we're dealing with a possible disability. So it should take your brain into, okay, What do I do? Standard disability procedure. What do I do? Interactive process. Talk to them. What can we do? Is there an accommodation? How do we deal with that? But we need a note from the doctor. We need to substantiate the medical condition. So they don't have to tell you what the medical condition is, but just substantiate that there is a condition, and here's the accommodation that's being requested, and then you go through the discussion. So yeah, it's not as easy as saying, too bad there's no protection for fear, because mental disabilities are always the hardest ones that I see employers struggling with, because there isn't any like overt proof, right? Someone who is a quadriplegic, you can see that.
Right.
Someone who suffers from panic attacks or generalized anxiety disorder, which is something I've been hearing about a lot, the people with generalized anxiety disorder, you don't see it. You don't see their anxiety attack. So that's hard.
It's hard too when you have management, maybe that they aren't as experienced with those medical conditions. So maybe they've not experienced it in their lives, so they may, it may not that's why I think you're right. Like with the training, it can help for them to identify those. And then I also think that it's underestimated what an adverse action is. That's a pretty broad term. Like it's not just firing someone, right,
No.
Susan?
No, I mean, that's something I've talked to people about. I'm like, you could move their desk and they could see it as an adverse action, right? You could take the stapler away and they say, my job required stapling, and all of a sudden I didn't have access to a stapler. Adverse action, right? Like,
I feel like I'm having Office Space like flashbacks. Isn't that where they took?
It's such a great movie.
I know. It's like, don't take his stapler away, but that is a good point.
But it's true. I mean, as long as the employee sees it as adverse, right? Then, they'd have to substantiate it to some degree. The stapler's a bit of an exaggeration, but it could work. It really could genuinely be.
Yeah, just moving job responsibilities around. Mm-hmm. Some people think if the pay is the same and the employer, if the job title's the same and the pay is the same, there's no adverse action happening. But that's not really what the case is. I'll say there's a much broader definition. You could even have a social setting where someone wasn't invited because they thought they might not want to be involved, with bowling or doing whatever. Right. And that could be interpreted as, adverse, and so need to be wary of that, I think, for sure.
Yeah. Be very careful. Retaliation is concerning. Yeah.
And then one last thing before we kind of wrap this up, as we're talking about this. So say we do get in that situation with our fear worker and they don't, they're at home, they're not, they're having some trouble responding because they are fearful about coming back into work. What are the options on communicating with that worker, the fearful worker at home, not wanting to come back into work? And they have like 40 excuses on why, all of them surrounding different versions of the fear. You know what I mean? And there's no medical condition really,
Well, that's the issue, right? So hopefully you can get on the phone with them and talk to them. That's usually the best way, but then there isn't proof of the conversation. So that's challenging. And under the FFCRA, you need to document that conversation. You should document it anyway, but the FFCRA is pretty clear about, when you're talking to someone about their not wanting to come into work related to COVID, that you need to document the conversation. You can talk to them through email. You can talk to them through text. All methods of communication are available, but the struggle is getting the employee to respond to you. And if we're dealing with a disability, the courts are pretty clear. You've got to give them a lot of time. It's not, hey, I need a doctor's note, I need it tomorrow, right? I'm not even talking about the FFCRA challenges or the COVID challenges of getting a doctor's note. You have to give them time. You have to be much more lenient when you're dealing with a disability to try to get them to work. Now, whether or not they fall under the FFCRA and you're going to pay them your paid sick leave for this, that you might not need to. If we're dealing with a disability that isn't exacerbated by COVID at the end of the day, that's what it's determined to be, which would be in this situation. It's hard to imagine a situation where it's not, when you're saying I'm afraid to come in because of COVID.
Right.
But the question about whether or not you have to pay them or if they fall under any paid leave is separate from how much time you need to give them to get the doctor's note, to get the accommodation, to talk through the interactive process. You have to give them time.
And if there is no medical condition and it just truly is a fear that may not be protected, right? And they're just scared to come in, then communicating with them and having the right information to communicate with them would be important. So if you haven't updated any contact forms with employees in a long time, that may be something to explore.
Yeah, make sure you have their right information. If you're furloughing individuals or laying them off, double check their contact information before you do so, right? Or if you're sending people home because there's been, they've been in contact with COVID, make sure you have their proper contact information. But employees need to make sure that they're giving you that information too. So, but it is a struggle. People move, they don't tell you they moved. You don't have their updated phone number or personal email or something like that. And what do you do? There's not really a right answer if you just don't have their proper information.
Yeah, it's tricky. It certainly puts the employer in an uncomfortable situation when they're trying to figure out, okay, do I hold this position or is this person never coming back? But, you can do the best you can do and just try to see if you can, have the best contact information with the individual, while they're on leave or when they're being furloughed. And I think that would be the best place to start to try to make sure that you have, because there's a lot more communicating going on nowadays via text, which I know we probably don't love.
Right.
And because just printing those out are awful because they're like all weird, but
keep them. Absolutely. You got to keep them. They disappear. They don't stay out there forever.
That's right. And I think iPhones have a natural elimination. I'm sure that the Androids do too, if you don't prevent that from that. But yeah, trying to secure that. But then the emails and then the phone calls and then trying to send letters out, it can just kind of get overwhelming if you don't have the right contact info for those employees on how to properly communicate with them. So I appreciate that. I think this was a good discussion, Susan.
Yeah, it's always a good discussion when I'm on the phone with you, Trisha.
Okay, do you mind if we do the legal skinny rundown?
I'm so excited. I've heard it so many times on your podcast. It's my turn. Yay!
Okay. Beach or mountains?
I would say mountains. I don't really like a lot of heat and sun. Now,
that kind of makes sense because you're up there in the Midwest. It's not how far we have to travel for a beach. Come on.
If like a pier and a lake was an option, I'd pick that one because I'm a big lake girl. But otherwise, mountains.
Mountains. Elvis or the Beatles?
That's hard for me. I was wondering how I would answer that one because I'm not really neither one of them is really my driving force, but I'd have to say Beatles over Elvis if I have to pick between those two. If you could throw in some like The Cure, that'd be great.
You're like the old guest that's let's redo the question.
You have other attorneys on here and they're not trying to break the rules. They're always breaking everybody else's rules.
I should have known if someone was going to break the rules, Susan, it would be you.
It'd be me. Yeah, that's for sure.
Okay. Most influential book you've read?
So I primarily do a lot of reading just for fun. So our day-to-day life is hard enough. I like to come home and turn my brain off. But I did have a book. I'm going to be very careful about the title that I really enjoyed recently. That's called The Subtle Art of Not Giving a, and then insert word that sounds kind of like fudge and hockey puck and somewhere in there. And I really thought that it was a good book because it really wasn't about not caring about things. It was about caring about what's important and learning how to let the rest of it go and how to set boundaries in your life. So that was important for me because as a business owner, and I'm like self-diagnosed ADHD. I'm jumping all over the place. So I don't have ADHD. I just pretend like I do.
It's easy to blur those boundaries for sure. Right. And I appreciate, since this is a family-friendly podcast, that you didn't go there. Okay. Dead or alive, what famous person would you invite to dinner?
Okay. So again, real, not fictional. Just saying.
Okay. It can be fictional. Just bend all the rules you want here, Susan.
Okay. Well, it would have to be Star Wars related because to me, that would be the number one. So I would probably pick Carrie Fisher.
She's real, though.
She's real, but really, what I want to talk to is Princess Leia. But Carrie Fisher is a real person who is sadly deceased. If I had my perfect table, it'd be like Carrie Fisher, Ruth Bader Ginsburg, Nelson Mandela. They work, right? That fits. Star Wars, Ruth Bader Ginsburg, same thing, right?
Princess Leia with the buns. That's who you want.
She'd be sitting at the table with the buns. I'd have Obi-Wan Kenobi showing up and he'd be hanging out with, Ruth Bader and Nelson.
Yeah, that's a dinner I would go to for sure, Susan. That sounds good.
Any dinner with me and my quirky guests is a fun.
I knew you were going to get Star Wars in here somewhere. You just
I
could
love
get through
Star
this
Wars.
one.
I
I
can't
know. Okay, finally, 1 minute or less. What is the skinny on the scared COVID-19 employee?
I would say make sure that you don't take it at face value. Just because someone's afraid, dig into the fear. What is the fear? Make sure we're not dealing with the disability, and see if there isn't something that you can course correct for that employee, to make them feel safer at work.
I love that. So if someone wants to get in touch with you, what's the best way for them to do that?
Well, you can always find me at the 3Bs at gmail.com. But also I'm on Facebook and Twitter and Instagram and LinkedIn. LinkedIn's under my name, but everything else is under at WPD Legal, or our website is WPDlegal.com.
Thank you, Susan.
Thanks for having me. This is so much fun. And I loved breaking the rules.
Of course you did. So that's Legal Skinny on the Fear COVID-19 employee. Thanks, Susan.
Thanks, Trisha.
Thanks for joining us on this episode of the Legal Skinny podcast. Do not forget to subscribe to get future podcast episodes. Also, check out LegalSkinny.com to join our newsletter and get details on all the educational resources we offer the employer. Also, disclaimer, remember Legal Skinny is for entertainment and informational purposes only, not meant to provide legal advice, and does not create an attorney-client relationship. Laws change or they differ by jurisdiction. So also remember, this is not a substitute for seeking legal counsel in your jurisdiction on the current law applicable to you.